Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, the idea for this video came from one of our loyal viewers, so a huge shout out to Desert Speed. Desert Speed was kind enough to ask this question, asked me to actually do a video on this. I took a look at it and I went, that's actually a pretty good idea. So today we are going to spend a few minutes talking about loaning a firearm to someone who might actually need it. All right, so this is what we're going to be talking about today. And Desert Speed, like I said, a huge shout out to him for coming up with this idea. The question is let's say I have a sister whose now ex-boyfriend is going kind of psycho on her, kind of stalking her, and she wants to borrow one of my firearms. Let's say that it's my sister-in-law. Let's say that it's my sister-in-law's neighbor, and any one of the scenarios that we could think about. Let's take a look at a mildly different example. The neighbor down the street, the sweet little old lady who lives there all by herself, some people have been bothering her, trespassing on her property. She's worried that they're going to break into the home. She wants to borrow one of your firearms. Can we legally do that? And is it a good idea? That's what we're going to be talking about today. So let's talk about the first point of inquiry. Can we legally do that? Well, that depends on a few different things. The first thing it's going to depend on is what is the relationship between you, the person who's loaning the firearm, and the person who is now receiving the loaned firearm. Okay, we know under RCW 9.41.113 that all transfers between private citizens must undergo a background check through a licensed FFL unless there is a statutory exception. The statute is 941.113 and the exception is found in subsection 4. Now we've been over this a few times before, but to refresh your memory, that section specifically states, this section does not apply to a transfer between immediate family members, which for this subsection shall be limited to spouses, domestic partners, parents, parents-in-law, children, siblings, siblings-in-law, grandparents, grandchildren, nieces, nephews, first cousin, aunts, and uncles that is a bona fide gift or loan. So absent that, one of those articulated familial relationships, okay, absent one of those family relationships, then any transfer, even a loan or a gift, shall be conducted through an FFL pursuant to 941.113. If, however, we do have that family relationship, can we loan them that firearm? Yes, we can. Can we do that without conducting a background check? Yes, we can under 941.113 sub 4. But we also have to be certain that the individual that we are loaning the firearm to is otherwise lawfully allowed to possess a firearm. Now, what happens if we do loan or deliver a firearm to a person believing that they are lawfully allowed to possess a firearm, but later finding out that in fact they were not? They were a convicted felon, they had an involuntary commitment, they had some domestic violence things, okay? If you knew or had reason to know that that person was prohibited from possessing a firearm, you likely are going to be on the hook for a violation of 941.080 or delivery to an ineligible person. Now, if you had no way of knowing, you possibly have a defense. Now, that statute, 941.080, delivery to ineligible people, specifically states, no person may deliver a firearm to any person whom he or she has reasonable cause to believe, 1, is ineligible under RCW 9.41.040 to possess a firearm, or 2, has signed a valid voluntary waiver of firearm rights that has not been revoked under RCW 9.41.350. So, if we have reason to know that this person is ineligible under RCW 9.41.040 for a litany of criminal convictions or mental health reasons, or we have reason to believe that this person has voluntarily forfeited, surrendered their firearm rights, what we call a white flag order under RCW 9.41.350, then we are guilty. If we deliver to a firearm that we know these people to be in these restricted categories, we're guilty of a Class C felony for every firearm that we deliver to that person. Now there's another rub, another reason for why we should think long and hard about doing that, and that lies in RCW 9.41.360. Now that is Washington's safe storage provisions, and although the statute does not really mandate how we store our firearms, it does mandate what happens if we allow unauthorized individuals to access firearms, and it even further describes the criminal liability we are if those unauthorized people access a firearm and then use it in the commission of the crime or to commit violence. And without getting too far into the details, the rule of law under 941.360 is if you allow an unauthorized person to gain access to a firearm who then later uses the firearm to injure or kill somebody, you are looking again at community endangerment in the first degree, a Class C felony. If you allow an unauthorized individual to access one of your firearms and they either discharge it, display it, or use it in the commission of a crime, you are looking at community endangerment in the second degree. That is a gross misdemeanor. And then finally, and perhaps most importantly, even though now we might understand what we have the right to do, we need to talk about what is doing the right thing. Now, I certainly recognize the real dangers that some of these people could be in, but we also have to recognize the dangers of a firearm in the untrained hands. I have 3 sisters, and candidly, I would not loan any one of them a firearm, not because I don't love them to death, but because I know that none of them are trained or versed at all on how to handle a firearm. The other thing we got to think about is, and this is kind of goes to the same argument I make on the may issue states, which is in the may issue states like California and New York, you have to demonstrate a need to really have a firearm. That is, the person who's most likely going to be given the license is the person who's most likely going to have to pull the trigger. It doesn't make a lot of sense. Well, loaning a firearm to a person who's in distress, loaning a firearm to a person who's undergoing some type of trauma, and it could be external by some creep, some stalker, some, vagrant or something like that, and I recognize all that. But now we are placing a deadly weapon into the hands of a person who is most likely going to need to use that deadly weapon. And while I love to give nice bright line rules, the bottom line is that this is on an individual basis. Do I have members of my family who I would loan a firearm to that I could do lawfully under 941.113 because of my family relationship? Yes, I do. Do I have also other members of the family who I love equally as much as those that I would loan a firearm, but I'm not going to give them a gun? Yes, I do. And it has no reason that I think that they're going to use the firearm to harm themselves intentionally, but I think they're perfectly capable of harming themselves or others unintentionally without proper training. So what's the point here today? Well, Desert Speed and everyone else, it's this. Can you loan a firearm to a person who may need to actually use it? Yes, you may. You can do so without conducting a background check under 941.113 subsection 4 as long as you have certain family relationships. But regardless of what that relationship is, you can never transfer a firearm under 941.080 to anybody that you have reasonable belief is otherwise ineligible to possess a firearm. And if we do transfer a firearm and the firearm is used in the commission of a crime and it turns out that that person was unauthorized, we also face criminal liability under 941.360. That gives you the legal rights. Is it the right thing to do? Again, I defer to your individual judgment. Listen, you may have more questions about this issue or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course, you can call us directly at 425-765-0487. Now let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.